So Bill, what are we going to talk about today?
Let's talk about the burden of proof.
What is that?
The burden of proof is what you have to prove at trial, essentially. And there are different standards, whether you have a civil case or a criminal case. Everybody's kind of heard beyond a reasonable doubt, which is the criminal standard. But in the civil setting, it's by the preponderance of the evidence. So it's kind of a vague term, and attorneys on the civil side like to say 51% or tipping the scales. So it's kind of a hard concept to communicate to jurors and people, because the case doesn't have to be perfect. You can have holes in the case, but if it makes more sense that something happened, more likely than not, then they should rule for that party.
Absolutely, and it really, people do get confused between the civil and the criminal. You know, if you consider in the recent news, like the George Floyd case, the jurors in that case had a much higher burden because they had to find that Derek Chauvin committed the acts he was convicted of beyond a reasonable doubt. You know, what would a reasonable person believe? I mean, it's a much, much greater standard than we have in civil court. However, I don't want us to make it look like it's an easy walk through the park, because the reality is that 90 to 95% of all civil trials, in personal injury anyway, end up in defense verdicts. So it is a real, it's not an easy burden, even though it's 51% or preponderance of the evidence or more likely than not. It is still a high burden.
Yeah, it's kind of like the sniff test. Does this pass the sniff test? Does it feel like it was happened or likely to happen? But yeah, communicating those things to the jury and kind of getting them to understand it. They have jury instructions that they're supposed to follow. They're just kind of words, and so if you can give them some illustrations to help guide them. But it's a challenge. Yeah, and then the insurance company they tend to pay on the good cases and put your feet to the fire on the tougher cases. So it makes sense that they might have a better win ratio in trial.
Absolutely.